This is the brief on the legal penalties for false testimony. We're breaking down the laws around lying under oath, and as you're going to see, the severity of your punishment depends entirely on who your lie affects and what's actually at stake. So first up, criminal cases. The penalty for lying against a defendant directly matches the severity of their potential sentence. Like, if they face the death penalty, the liar faces the absolute maximum penalties. But here's a totally bizarre twist. Lying in favor of a defendant is also a crime. You're criminally liable even if the court didn't buy the lie or the defendant didn't even benefit from it. Second, let's look at civil lawsuits and perjury. Here the penalty is tied to the amount of money in controversy, specifically whether it's above or below 1 million pesos. Now, for general perjury, the lie absolutely must be about a material matter. Think of it this way. Lying about your age on a document isn't perjury if the legal issue is about a stolen car, because the lie doesn't affect the court issue. Finally, the ultimate crackdown, public officials. If a government employee commits perjury, they face the absolute maximum penalties. So why drop such a massive hammer on officials? Well, because it completely breaks systemic trust. They get hit with a fine of up to 1 million pesos and are permanently disqualified from holding any government office. Ultimately, the law doesn't just punish the act of lying, it scales a punishment directly to the amount of damage that lie could inflict on someone's life, their wallet, or the justice system itself.
Welcome to the Architecture of Truth, a structural synthesis of the revised penal code, focusing on the mathematical calibration of harm in false testimony, specifically Articles 180 through 184. The justice system relies on the absolute assumption of truth. When a witness lies, they fracture the very architecture of justice. The revised penal code treats the penalty for false testimony as mathematically proportional to the precise harm the lie inflicts. We categorize the lie using a diagnostic matrix. False testimony is differentiated by the preceding type, criminal or civil, and the direction of the lie, which determines the primary penalty driver. This harm calibration decision tree illustrates how the context of the lie dictates the applicable article. For instance, in a criminal case, the penalty is calibrated based on whether the false testimony harms or helps the defendant. Article 180, malice against liberty, applies when the lie is against the defendant in a criminal proceeding. Under the Maneja doctrine, the crime is the attack on the system, meaning liability obtains even if the court ignores the false testimony. The penalty for the liar under Article 180 is a mirror of harm. It is directly proportional to the threatened sentence of the defendant, with penalties escalating from arresto mayor up to reclusion temporal. Article 181, the asymmetry of false leniency, pertains to false testimony favorable to the defendant. The penalty is less severe, but still follows rules like the, quote, negative statement rule, and the requirement for spontaneous rectification to defeat malice. Article 182 covers malice against property in civil cases. A monetary threshold of P1 million is key. The penalty escalates significantly if the amount in controversy exceeds this threshold. This article strictly applies only to civil cases. Article 183 addresses perjury in solemn affirmation, applying to false sworn statements made outside of judicial proceedings, such as false affidavits. Perjury is penalized to preserve the integrity of the solemn affirmation itself. The perjury filter illustrates the 4 necessary elements of punishable perjury under Article 183. Statements that fail to meet criteria like being material or willful and deliberate will bounce out and are not punishable. Article 184 concerns the vector of the lie. This is the person who willfully and knowingly offers the false evidence, even if they are not the source. The vector suffers the exact same penalty as the source of the false testimony. We must distinguish between subornation, Articles 180 to 183, where an offender induces a witness to lie, and offering false evidence, Article 184, where the lie already exists and the offender merely introduces it as evidence. The ultimate synthesis introduces aggravating multipliers, triggered if the offender is a public officer. This systemic betrayal leads to the maximum penalty, a heavy fine, and perpetual absolute disqualification, as the system purges its guardians who weaponize falsehood.
You know, we always hear that a lie is a lie. Simple, right? But what if I told you that in the eyes of the law, especially when you're under oath, some lies are seen as way more damaging than others? Today, we're going to dive into the really fascinating world of false testimony, where the punishment isn't one size fits all. Instead, it's carefully measured to match the harm that was caused.
So, let's just get right to the big question. What is the real price of a lie under oath? Is it some fixed fine or a set amount of time? Or does it all depend on who you're lying about, what you're lying about, and where you're telling that lie? Well, as you're about to see, the law has some very specific answers. Okay, first things first, let's get our terms straight. We're talking about false testimony. And this isn't about, misremembering a detail or getting a date wrong. No, this is the deliberate, intentional act of saying something you absolutely know is false while you're under oath. That intent part, it's everything. All right, let's jump in right where the stakes are the absolute highest. A criminal trial. I mean, think about it. A single lie in this setting could literally cost someone their freedom or maybe even their life. It's why the law comes down so hard on this, but it also makes a really important distinction. So you've really got two sides of the same coin here. You've got Article 180, which is all about lies against the defendant. The kind of lie that could put an innocent person in a cage. And then there's Article 181, which covers lies for a defendant, the kind that might help a guilty person walk free. And as you can probably guess, the law does not see these two things as equal. So how exactly are they different? Well, this is where that sliding scale idea really comes into play. When someone lies against a defendant, the law creates a direct link. The punishment for the person who lied is tied directly to the damage they caused, meaning the actual sentence that the wrongfully convicted person got.
This table really just lays it all out, doesn't it? You can see that direct connection plain as day. If your lie results in a death sentence for someone, you, the false witness, are looking at reclusion temporale. That's a serious long-term prison sentence. If the sentence was a bit less severe, like reclusion perpetua, your penalty is prisión mayor. It just keeps scaling down, matching the harm, all the way to arresto mayor, which is a much shorter jail time if the defendant ended up getting acquitted anyway.
Now let's flip it. What if you lie to help someone out? Article 181 shows us the penalties are still serious for sure, but they're generally less severe than if you lie to get someone convicted. And that really tells you something about the law's priorities, right? It seems much more focused on protecting the innocent than it is on making sure every single guilty person gets caught. Okay, so we've talked about what happens when someone's freedom is on the line. But what about when it's all about the money? Let's pivot to civil cases. This is where the fight is usually over finances. And as we're about to see, that same sliding scale idea pops right back up. In the world of civil cases, there's a magic number. And that number is 1 million pesos. According to Article 182, this is the magic line in the sand. It's the threshold that separates a lesser punishment from a much more serious one. And honestly, it's pretty straightforward. If the amount of money at stake in the lawsuit is more than 1 million pesos, the penalty for lying under oath is higher. If it's 1 million or less, or you just can't put a price tag on it, the penalty is lower. It's that same principle all over again. The punishment fits the potential damage. Only this time, we're talking about financial damage.
So we've spent a lot of time talking about lying inside a courtroom, but what about lying on paper? We've all signed an affidavit or a document where you swear that everything you've written is true. Well, lying on those, that's a crime all on its own. It's called perjury.
So what exactly makes something perjury? Well, under Article 183, you've got to check 4 boxes. First, the lie has to be about something important, what the law calls a material matter. Second, the oath has to be given by someone legally allowed to do that, like a notary public. Third, and this is crucial, it has to be a willful, deliberate lie, not an accident. And finally, the sworn statement you're making has to be one that's actually required by law. And you better believe the law takes perjury seriously, but it holds a special kind of anger for public officials who commit it. If a government employee or officer lies under oath, they are looking at the absolute maximum penalties, the longest possible prison sentence, a massive fine, and they're banned from ever holding public office again, for a life. Okay, so we've established it's a crime to lie under oath. We get it, but what if you're not the one telling the lie? What if you're the puppet master, the person who gets somebody else to lie for you in court? Well, the law has a very clear answer for that too. And the answer is, you're just as guilty, period. Under Article 184, if you knowingly bring in a witness that you know is going to lie, or you submit a document you know is false, the law punishes you as if you were the one who told the lie yourself. There's no escaping responsibility just because the words didn't come out of your mouth. So, after all of this, after looking at criminal trials and civil cases and perjury, what's the big idea? What's the one single unifying principle that connects all these different laws? Well, it all boils down to the very foundation of our entire justice system. It's this, right here. This is the absolute key takeaway from everything we've talked about. The law punishes the lie based on the damage it can do. A lie that could cost a life is punished more severely than a lie that could cost money. A lie that condemns an innocent person is treated far more harshly than one that frees a guilty one. The whole system is built on this idea of proportionality.
And that leaves us with one last big question to think about. Our entire justice system, it's built on words. It's built on the promise that people will tell the truth when they swear an oath. When that trust gets broken, the whole system starts to shake. So the real issue isn't just about the punishment for lying, it's about what we, as a society, decide is the ultimate value of truth. Thanks for joining me for this one.
Imagine you are sitting on a witness stand. You place your hand on a Bible, you look a judge dead in the eye, and you tell a blatant, undeniable, meticulously constructed lie.
Just a total fabrication.
Exactly. And your goal is to help a guilty person walk free. You know it's a lie. The judge eventually figures out it's a lie.
Right.
And yet, depending on one tiny, almost microscopic legal technicality, the law might say you are completely innocent of perjury.
It sounds impossible, honestly. It sounds like a broken system.
Right. It defies every instinct we have about right and wrong. So, okay, let's unpack this, because today we are venturing into a corner of the justice system that is, well, incredibly complex.
Very much so.
We have a highly specific, fascinating stack of legal documents to get through for this deep dive. We are looking at the legal architecture of the Philippines.
Specifically, the revised penal code.
Right, Articles 180 through 184. And we're factoring in some massive recent amendments, Republic Acts 10951 and 140 Feet 94.
Plus a whole library of pivotal Supreme Court case law.
Yeah, case law that stretches back over a century. So our mission today is to decode what actually happens when someone lies under oath. Because the law, surprisingly, does not treat all lies equally.
What's fascinating here is that the law measures a lie not just by its falsity, but by its potential collateral damage.
Like the blast radius.
Exactly, the blast radius. This isn't just a simple list of punishments handed down from on high. It is a profound reflection of how a justice system protects its own integrity.
So how does that work in practice?
Well, think of a courtroom as a massive, complex machine, and the only fuel that machine can run on is facts.
Right.
If you feed it lies, the machine breaks. So the penalties we were going to talk about are carefully calibrated based on how badly you are trying to break that machine.
And whose life you were trying to destroy in the process, I assume.
Exactly.
I want to start exactly there, with the lies designed to destroy someone. In our sources, this falls under Article 180.
Which deals with false testimony against a criminal defendant.
Right, so this is the scenario where you take the stand and point the finger at someone who is on trial, deliberately lying to put them behind bars.
Yes.
And what struck me reading the penal code isn't just that it's illegal, it's the philosophy behind the punishment. It's not like a flat sentence.
No, not at all. It is highly variable. Article 180 establishes a sliding scale of punishment governed by strict proportionality.
Meaning the punishment fits the lie.
Basically, the punishment for the person telling the lie perfectly mirrors the danger they put the innocent defendant in.
Wow.
It's an eye for an eye applied to perjury.
Which is terrifying if you really think about it. I was trying to map out the math in my head.
It gets intense.
So if the person you are lying about is facing the absolute worst case scenario, say they're facing the death penalty, and you get up there and fabricate a story to send them to death row, what happens to you when you get caught?
The law hits you with reclusion temporal.
Okay, for those of us not fluent in the penal code, what does that mean?
In the Philippine legal system, that is an incredibly heavy penalty. You are looking at an incarceration period ranging from 12 years and 1 day up to 20 years.
Wait, really? So you try to end someone's life with a lie, and the law takes away up to 2 decades of yours.
Precisely. And that mirroring continues all the way down the scale.
Okay, walk me through the rest of the scale.
Sure. If the defendant is facing life imprisonment, which is reclusion perpetua, the liar receives prison mayor.
And how long is that?
That's 6 to 12 years.
Still a massive chunk of your life.
Right. And if the defendant faces a lesser afflictive penalty, the liar gets hit with up to 6 years. Plus, and this is a modern update from Republic Act 10951, a fine of up to 200,000 pesos.
Okay, so it's essentially a twisted mirror. The darker the shadow you try to cast over someone else's life, the deeper the legal hole you dig for yourself.
That is the core philosophy.
You are gambling with your own freedom using the exact stakes you are forcing upon the defendant.
You are tying your fate to the fate you tried to engineer for your victim.
But I need to stop you there, because I was reading through the notes on how Article 180 is actually applied in real courtrooms, and I found something that completely short-circuited my brain.
Oh!
Yeah. The lowest tier of punishment on that sliding scale applies even if the defendant is outright acquitted.
Yes, that is correct.
Okay, but it goes further. The jurisprudence says criminal liability applies even if the false testimony was not considered by the court.
Right, it doesn't matter if it was ignored.
So, let me pitch you a scenario. I am a terribly incompetent liar.
Okay, I'm picturing it.
I get on the stand, I'm sweating profusely, my story contradicts itself 3 times in 5 minutes. The judge sees right through me immediately, rolls their eyes, completely ignores everything I say, and acquits the defendant.
Total disaster on the stand.
Exactly. My lie caused absolutely zero harm. The defendant walked free. The judge wasn't fooled.
Right?
If there was no damage and the lie failed spectacularly, why am I still committing a crime?
Because you are looking at the crime through the lens of the victim's outcome rather than the attacker's intent.
Okay, elaborate on that.
To understand this, we have to look at the landmark case of People versus Malaysia.
The Malaysia case, right?
The Supreme Court in that case laid out 4 strict elements required for this crime. First, an existing criminal proceeding.
Sure.
Second, you testify falsely under oath against the defendant.
No.
Third, you know what you are saying is false. And fourth, the defendant gets a final judgment, either conviction or acquittal.
Okay, but notice what isn't in that list of elements. The court doesn't require the lie to actually work.
Exactly. The crime of false testimony under Article 180 is not defined by the success of the lie.
So what is it defined by?
It is defined by the attempt to pervert the course of justice.
Oh, I see.
If we go back to the idea of the courtroom as a machine, the crime isn't just the fact that you tried to hurt the defendant.
Right.
It's that you launched a direct attack on the judicial system itself.
So if I walk into a bank, point a loaded gun at the teller, but the gun jams,
Yeah.
I don't get to say, well, nobody got shot and I didn't get any money, so no harm, no foul. I still attempted the robbery.
That is a perfect parallel. The judge ignoring your incompetent lie means the system's defenses worked. The judge was sharp.
Right, the system did its job.
But the fact that you took an oath, invoked the solemnity of the court, and willfully tried to introduce a virus into the mainframe, that is what triggers your liability.
Because you still tried.
Exactly. If the law only punished successful lies, the state would essentially be saying it is perfectly fine to try and frame an innocent person, just make sure you don't get caught before the jury reads the verdict.
Wow, yeah, that would be chaos.
The law cannot allow the institution to be a playground for malicious experimentation.
Okay, that makes total sense. It is the malice, the absolute intent to corrupt the system that the state is hunting down.
Precisely.
Which naturally makes me wonder about the flip side. We've established that lying to destroy someone brings this severe mathematical retribution.
Yes.
But what happens when the intent flips? What about lying to save someone? Like taking the stand to give a friend a fake alibi.
That's a very different scenario.
Does the law go easier on you because you were acting out of loyalty instead of malice?
This brings us to Article 181, which covers false testimony favorable to a defendant.
Favorable, okay.
And this is where the psychology of the law gets incredibly intricate. The law recognizes that a witness might lie out of misplaced loyalty, pity, or a misguided sense of protecting a loved one.
So the motive isn't evil in the same way framing someone is.
Exactly.
So the penalties drop.
They do, but they are still substantial. You aren't facing 20 years in prison for trying to give your buddy an alibi.
Right, that would be extreme.
But if the crime they are accused of is a serious felony, you are still facing jail time up to several years and that 200,000 peso fine.
Because you're still lying to the court.
The core principle remains. You are still feeding false data into the justice machine.
But this is where I get tripped up again by the source material. I was trying to figure out what favorable actually means in a courtroom.
It can be a tricky definition.
Yeah, and I read something that seems like an absolute paradox. There are these 2 cases. I think it was U.S. versus Adolfo and People versus Reyes.
Ah, yes. 2 very important cases.
And they established that the false testimony doesn't need to actually result in an acquittal.
Right.
But even wilder, according to the Adolfo case, the testimony doesn't even need to ultimately benefit the defendant at all.
It is deeply counterintuitive. You are being punished for giving testimony favorable to the defendant, even if the testimony was practically useless to them.
How does that even happen in reality?
Well, let's play it out.
Okay, let's say my friend is on trial for a bank robbery that happened at exactly noon on a Tuesday.
Okay. Noon on a Tuesday.
I take the stand, and I swear under oath he couldn't have robbed the bank. We were having lunch together at noon on Wednesday.
Right, so you've got the wrong day.
I got my days completely mixed up. My lie didn't give him an alibi for the actual crime.
Not at all.
It didn't help his defense attorney at all. It was a useless lie. Am I still catching an Article 181 charge?
Yes, you are.
Even though it was useless.
Even though it was useless. And to understand why, we have to look all the way back to a decision from the Supreme Court of Spain on January 4th, 1904.
Wow. Okay. Going way back.
Which heavily influenced this section of the Philippine Penal Code. The legal definition of favorables here isn't about the tactical outcome of the trial.
Then what is it about?
It is entirely about the nature of your statement and your intent when you made it.
So the law is isolating my brain at the exact moment I open my mouth.
Precisely.
Yeah.
The court asks, was this statement designed by the witness to help the defense?
Yes.
Was it objectively false?
Yeah.
Did the witness know it was false?
Yeah.
The fact that your lie was tactically useless or that you were confused about the dates doesn't erase the perjury.
Yeah.
You still committed the act of lying under oath with the intent to derail the prosecution.
It's like throwing a life raft to a drowning man. But the raft has a massive hole in it and sinks immediately.
That's a good way to picture it.
The law says, we don't care that the raft sank. We care that you tried to interfere with the drowning.
That's a bit dark, but legally accurate regarding the interference.
Okay, what else did the Spanish jurisprudence say?
Well, speaking of that, there is another fascinating wrinkle from an 1883 decision from the Supreme Court of Spain regarding how these lies are constructed.
Oh.
It established that false testimony can be committed by a negative statement.
A negative statement? You mean like just denying something?
Yes.
Because usually when we think of perjury, we picture someone actively spinning a web. Like, I saw him do it, or he handed me the gun.
Exactly. We think of creative fabrication.
Right.
But a negative statement is a deliberate denial of reality.
Give me an example.
If the prosecutor asks you, were you present at the warehouse on the night of the murder? And you answer, no, I was not, when in fact you were standing right there.
That is false testimony.
Yes. You are withholding a truth that the court desperately needs to construct the timeline.
Oh, I see.
A lie of omission or a deliberate denial of a factual event is treated with the exact same severity as a proactive, creative lie.
Okay, let me throw a wrench into this because I want to find the boundary between a lie and just being painfully wrong.
Okay, let's find that boundary.
Let's imagine a scenario. I am called into court as an expert witness. I'm a highly paid forensic handwriting analyst.
Fancy.
The defendant is accused of forging a signature to steal millions from a company.
Okay.
I get on the stand, I look at the microscopic loops on the letters, I measure the pen pressure, and I confidently declare to the jury, in my professional opinion, the defendant absolutely did not sign this check.
All right, you've made your stance.
But it turns out, I am completely, utterly wrong. My analysis is garbage. The defendant signed it in front of 3 hidden cameras.
Oh, wow.
Has I committed false testimony under Article 181? I swore to tell the truth, and I said something that was factually false to help the defendant.
That is a brilliant distinction, and it is exactly what the Supreme Court tackled in the case of U.S. versus McGovern.
Okay, what did they say?
In your scenario, you are not guilty of false testimony.
Really? Why not?
The court in McGovern drew a massive vital boundary between a statement of fact and a statement of opinion.
Okay, walk me through that boundary. Why does my opinion get a pass?
Because false testimony requires the willful misrepresentation of a factual experience.
A factual experience, like what?
Did you hear the gunshot? Were you inside the restaurant? Did you see the red car? These are objective realities that you either experienced or you didn't.
Right, that makes sense.
An expert's opinion, however, is an interpretation of facts based on their specialized training.
Okay.
When you testify about the loops in the handwriting, you are offering your professional judgment.
Even if it's terribly wrong.
Exactly. Even if that judgment turns out to be objectively embarrassingly wrong, you are not committing perjury, provided you honestly hold that opinion.
So the only way I'd be committing perjury in that scenario is if I didn't actually believe my own analysis.
Right.
Like if I looked at the signature, knew the defendant forged it, but took a bribe to say otherwise.
Yes. But as you can imagine, proving that an expert witness doesn't truly believe their own stated opinion is incredibly difficult for a prosecutor.
I imagine it's almost impossible unless you have a recording of them admitting it.
Pretty much. However, the McGovern case adds a very sharp caveat to this protection.
Oh, what is it?
While your opinion might be protected from perjury, the factual statements you make to qualify as an expert are not.
So if I get on the stand and say, I have a PhD in forensic document analysis from Harvard, but I actually dropped out of high school.
Then you have crossed back into perjury.
Because that's a fact.
Exactly. Characterizing yourself as an expert using fabricated credentials is a false statement of historical fact.
Right. You either went to Harvard or you didn't.
Yes. The court relies on your credentials to decide whether to listen to your opinion. If you lie about the credentials, you are corrupting the proceeding.
I love that. You have the right to be terrible at your job, but you don't have the right to lie about having the job.
That's a perfect summary.
That is such a practical line. Let's look at another angle of this that happens in almost every single criminal trial.
Yeah.
What if the defendant lies for themselves?
Ah, the self-serving lie.
Yeah, like, I am on trial for theft. I take the witness stand in my own defense. I look the judge in the eye and say, I didn't steal the car.
Okay.
But the prosecutor proves beyond a shadow of a doubt that I did. Can the state charge me with the theft and then slap an Article 181 false testimony charge on top of it because I lied to save myself?
This is one of the most common questions in criminal law.
I bet.
And the Philippine Supreme Court addressed it head-on in U.S. versus Solomon. The answer is no.
No perjury charge.
Correct. A simple denial by the accused is not false testimony. The law fundamentally recognizes the human instinct for self-preservation.
Right, nobody wants to go to jail.
Exactly. You are constitutionally presumed innocent, and you have the right to plead not guilty.
Okay.
If you take the stand and merely deny participation like, I wasn't there, I didn't take the money, you cannot be subsequently charged with false testimony for that denial.
Even after you were convicted of the main crime.
Even then.
Which makes total logistical sense.
Yeah.
If every guilty verdict automatically spawned a second trial for perjury because the defendant pleaded not guilty, the court system would collapse into a never-ending loop of litigation.
Exactly. It would be functionally impossible to manage.
Right.
But the Solomon ruling, does not give defendants a blank check to lie. It establishes a very hard boundary.
What's the boundary?
If the defendant goes beyond a simple denial for self-preservation and instead begins to construct a complex fabrication that falsely frames someone else for a grave offense, they lose that protection.
Okay, let me make sure I understand the line. If I say I didn't steal the car, I am safe. But if I say I didn't steal the car, my neighbor John stole it, he showed me the keys and laughed about it, and I know for a fact John was out of the country. Now I've crossed the line.
Precisely. You have moved from defensive self-preservation to an offensive attack on an innocent third party and the judicial system.
I'm weaponizing the lie.
Exactly. The Solomon protection only applies to simple denial. Falsely imputing a grave offense to another person while under oath is where a defendant opens themselves up to a perjury charge.
Here's where it gets really interesting to me.
Okay.
We've spent all this time establishing these rigid mathematical rules about malice, intent, and punishing lies.
Right.
But then I came across a concept in the case law, specific a case called People versus Amble, that feels completely out of place. It feels almost forgiving.
Ah, yes.
It's the concept of spontaneous rectification.
Yes. It is a beautiful nuance in the penal code because it acknowledges human fallibility in high-stress situations.
Okay, so imagine I am on the witness stand. I am terrified.
Very
The defense attorney is staring holes through me, the prosecutor's badgering me, and I crack under the pressure. I tell a lie to try and help my friend who was on trial.
Okay.
But as I'm sitting there, my conscience kicks in. The guilt washes over me. Or maybe I just realize how much trouble I'm in.
Right, the gravity hits you.
Before my testimony's over, before the trial ends, I raise my hand and say, wait, I lied. That wasn't true. Let me tell you what actually happened.
Okay.
The Amble case is that if I do that spontaneously, I negate the false testimony. I don't go to jail.
That is correct.
Now, I have to push back on this.
Go for it.
Why does the law allow a take-back-see on a felony? Doesn't this create a massive loophole?
It might seem that way.
It basically tells witnesses, go ahead and lie, see if you can get away with it, and if the prosecutor catches you in a trap, just yell, I take it back, before you step down.
It looks like a loophole if you only view the law as a punishing mechanism.
Okay, how else should I view it?
If we connect this to the bigger picture, the ultimate primary goal of the judicial system is to discover the truth and render a just verdict.
Right.
It is not merely to accumulate perjury convictions.
So it's about the final product of the trial.
Exactly. Think about the psychology of a witness who lies. Once the lie leaves their lips, if the law says you are now permanently guilty of a felony no matter what you do,
They're trapped.
Right. What incentive do they have to ever correct the record? They will double down. They will cling to the lie out of sheer terror of going to prison.
And the court never gets the truth.
Exactly. By allowing for spontaneous rectification, as established in People versus Amble, the court is saying that correcting a mistake before the damage is permanent negates the malice or criminal intent required for the crime.
Wow.
A redeemed witness who finally tells the truth before the gavel falls is infinitely more valuable to the justice system than a terrified witness locked into a lie.
So the law sacrifices a potential perjury conviction to secure the truth of the main trial. That is profound. It's an incredibly pragmatic approach to human nature.
It really is.
All right, so far we have been operating entirely in the realm of criminal cases. Life, liberty, decades in prison. But the justice system doesn't just protect freedom, it protects property. Let's pivot to Article 182.
Which covers false testimony in civil disputes.
Right.
This is a massive shift in stakes. Criminal cases deal with the awesome power of the state to lock someone in a cage. Civil cases deal with the relationships between individuals or corporations.
So broken contracts, property boundaries, inheritance, corporate damages.
Exactly. Above all, they deal with money.
Always comes back to money.
And because the stakes are purely economic, the architecture of the penalties under Article 182 shifts entirely to match.
The penalties here are directly tied to the cash value of the lie. The financial thresholds dictate everything. Let me outline the stakes based on the RA 10951 amendments, because the numbers here are aggressive.
Very aggressive.
If you give false testimony in a civil case, and the amount in controversy, the amount of money the two sides are fighting over exceeds 1 million pesos.
Okay.
The penalty is prison correctional in its minimum period, which means prison time. But the fine, the maximum fine, jumps to 1,200,000 pesos.
Yes. Notice that the fine can exceed the actual threshold of the controversy itself.
Oh, wow. I didn't even catch that.
It is designed to be financially ruinous.
And if the dispute is under 1 million pesos, or if the amount cannot be easily estimated, like a fight over a trademark or a restraining order where a dollar value isn't the point, the penalty is lower and the fine caps at 200,000 pesos.
Right.
I want to pause and look at why the law draws this line so aggressively. Think about what a civil trial is. Two parties are fighting over the fabric of commerce.
Yes.
They're fighting over land a family has owned for generations, or a contract that a small business relies on to keep its doors open.
The stakes are incredibly high for the people involved.
A calculated lie in this arena isn't just a misstatement. It is essentially an attempt at financial theft. But you are trying to use the judge as your getaway driver.
Using the judge as your getaway driver is an incredibly apt analogy.
You are trying to trick the court into legally confiscating someone else's money and handing it to you.
You are winganizing the judicial apparatus for pure financial gain, and because of that, the state takes it very seriously.
Clearly.
However, because civil litigation can be incredibly messy and complex, the elements required to prove civil deceit under Article 182 are remarkably strict.
So they can't just nail you for any little thing.
No, the prosecution can't just point to any inaccurate statement in a deposition and scream perjury.
Let's break down those elements. If someone wants to nail a witness for lying in a civil dispute, what exactly do they have to prove?
First and foremost, the testimony must be given in a civil case.
Okay, seems obvious.
But jurisprudence provides a vital, often overlooked boundary here. In the case of People versus Hernandez, the Supreme Court explicitly ruled that Article 182 does not apply when the testimony is given in special proceedings.
Wait, I need you to clarify that. For someone not steeped in procedural law, what is the difference between a civil case and a special proceeding? Aren't they both just non-criminal court issues?
They are, but their nature is fundamentally different.
How so?
A civil case is generally adversarial. It's person A actively suing person B. You breached my contract, you hit my car, you stole my trademark. One party is demanding redress from another.
Okay, fighting over something specific.
A special proceeding, on the other hand, is generally a remedy by which a party seeks to establish a legal status, a right, or a particular fact.
Can you give me an example?
Think of probating a will, an adoption proceeding, or a petition to legally change your name.
Ah, okay.
While someone might eventually oppose it, it doesn't start as a fight between two parties over money. People v. Hernandez tells us that lying in the arena of a special proceeding does not trigger the specific financial thresholds and penalties of Article 182.
Okay, that is a massive technical distinction that could save someone's bank account.
It really is.
What are the other elements?
Second, The testimony must relate specifically to the issues presented in that case.
Right.
Third, the testimony must be objectively false. Fourth, the offender must know it is false.
Which is the willful deceit part.
Exactly, as established in cases like People versus Colantes and U.S. versus Vasquez.
Okay.
But the fifth element is arguably the most critical, and it was heavily defined in U.S. versus Aragon.
What is it?
The testimony must be malicious and given with the specific intent to affect the issues presented in that specific civil case.
Intent to affect the issues. Okay, let me test that logic with a hypothetical.
Let's hear it.
Person A is suing person B over a massive 50 million peso land dispute.
A big one.
Person A takes the stand. During cross-examination, the opposing lawyer brings up person A's personal life to rattle them and asks them where they went on vacation last summer.
Okay.
Person A, out of sheer embarrassment because they went somewhere cheap, lies under oath and says they were in Paris. It is a documented lie under oath.
Right.
But does it violate Article 182?
Based on U.S. versus Aragon? No.
Really?
Yeah.
Even though it was a lie under oath?
Yes, because while it is a lie and it was under oath, it lacks the malicious intent to affect the specific 50 million peso land dispute.
Because the vacation doesn't matter to the land title.
Exactly. Where they went on vacation has zero bearing on who owns the title to the land.
Okay.
It might severely damage their credibility in the eyes of the judge, which is bad for their case.
Yeah, you don't want to look like a liar.
But it does not fulfill the elements of civil deceit because it wasn't deployed as a weapon to steal the land. The law here is focused on punishing the lie as a tool of fraud, not just punishing general moral dishonesty.
It is so targeted. It is like a sniper rifle.
Huh.
The law only fires if you are aiming the lie directly at the core of the financial dispute.
Exactly.
All right, so far we have been inside the courtroom. Criminal trials, civil trials, witnesses sweating under cross-examination on the stand.
The classic TV drama stuff.
Yeah. But the reality is the vast majority of our interactions with the legal system and with oaths in general do not happen in front of a judge in a courtroom.
No, they don't.
They happen out in the wild. And that brings us to Article 183, perjury and false affidavits.
This is the catch-all. Article 183 is essential because it governs the everyday bureaucracy of life.
Like what?
This covers swearing to facts at notary desks, signing documents in government offices, applying for licenses, filing insurance claims.
This is the stuff everyone does. This is checking a box and signing your name, swearing you haven't been convicted of a crime when you apply for a job.
Right.
Or signing a sworn statement detailing how your car got rear-ended for the insurance adjuster.
Exactly. Article 183 defines two primary paths to committing perjury.
What are they?
The first is falsely testifying under oath in a setting other than a judicial proceeding, like a formal administrative hearing.
Okay.
The second is making a false affidavit signing a sworn piece of paper. The penalty for knowingly making untruthful statements under these conditions can be quite severe, reaching prison mayor in its minimum period.
So we are talking about serious prison time for lying on a piece of paper.
We are.
But again, just like we saw with the civil cases, the law doesn't just pull out the handcuffs for every single typo, misstatement, or irrelevant lie.
Thankfully, no.
There is a very specific, powerful filter that determines what actually counts as perjury.
Yes, and that filter is the concept of material matter.
Material matter.
This is discussed extensively in two major cases, U.S. versus Estrada and People versus Banzel.
Okay, explain the materiality rule.
The materiality rule is the absolute bedrock of Article 183. A statement is only considered material matter if it is the main fact subject of the inquiry or a circumstance that strongly tends to prove that fact.
Or something that legitimately affects the credit of the witness testifying.
Yes. If the lie does not relate to a material matter, perjury has not been committed, legally speaking.
I want to dive deep into the Banzel case to illustrate this, because the human element of it is fascinating, and the legal outcome is shocking.
It is a wild case.
Let's set the scene. Imagine a government employee who is subjected to an official, formal administrative investigation.
Okay.
The charge against them is immorality. Specifically, they're accused of having an illicit affair, which violates civil service rules.
Right.
During this official investigation, the employee is put under oath. The investigator asks them for their basic background details, including their civil status.
Right.
The employee swears under oath that they are single.
Oh.
But the investigators pull records, and they are legally married.
Uh-oh.
It is a blatant, documented, undeniable lie made under oath to a government investigator. Is that perjury?
To a layperson, it looks like open and shut perjury. But based on the ruling in People versus Banzel, the Supreme Court said no, it is not perjury.
How is that possible? They lied under oath.
Because of the materiality rule, the court had to isolate the core purpose of the investigation.
Okay.
The investigation was not about whether the employee was married or single.
It was about the affair.
Exactly. The investigation was specifically about the act of immorality, the alleged affair. The court reasoned that the employee's legal civil status might be interesting background context, but it was not the core fact required to prove or disprove the immoral act itself.
Oh, because an unmarried person can commit immoral acts just as easily as a married person in the context of those specific civil service rules.
Precisely. Therefore, the false statement about being single was deemed not material to the specific charge being investigated.
Wow. So you can look a government investigator in the eye, lie under oath about your own life, completely get caught in the lie, but if the lie is legally deemed off-topic to the main charge, you walk away from the perjury charge entirely.
Yes, and the jurisprudence is very consistent on this. In U.S. versus Estrada, someone lied under oath about their place of residence.
And the court said,
The court looked at the case and said, where this person lives has absolutely nothing to do with the crime we are investigating. Immaterial, not perjury.
but this brings up a really thorny semantic issue that I saw in the case of People versus Kappenlack.
Kappenlack.
The Supreme Court made a huge point of distinguishing between a detail being pertinent and a detail being material.
Yes, they did.
And honestly, that sounds like lawyers just splitting hairs to bill more hours.
Oh,
What is the actual difference?
it's subtle, but it's crucial.
Let me try an analogy. Let's say an investigation is a game of Jenga. Every fact is a block.
Okay, I like where this is going.
Pertinent details are the loose blocks sitting near the top of the tower. They're part of the game, they're related to the tower. But if you pull one out, or if a witness lies about one, the tower still stands.
Right.
The investigation isn't destroyed. But material details are the blocks at the very bottom, the load-bearing pillars.
Exactly.
If a witness lies about one of those, the entire structure of the investigation collapses. Does that track with Kappenlack?
That is a phenomenal analogy, and it perfectly encapsulates the Kappenlack ruling. A fact can be pertinent, meaning it is somewhat relevant, it adds color, it's a block in the tower, but mere pertinence is not enough for a perjury conviction. The prosecution must provide competent, undeniable proof of materiality. They have to prove that the lie was a load-bearing pillar.
Right.
If the lie didn't have the power to collapse or drastically alter the outcome of the inquiry, the high bar for perjury hasn't been cleared.
Okay, so the lie itself has to be powerful enough to matter. But what about the person you are telling the lie to? Let's say I sign a sworn affidavit containing a massive load-bearing material lie. Does it matter who is holding the stamp or administering the oath?
It matters immensely. In fact, it is the second crucial element of Article 183.
Which is?
The statement or affidavit must be made before a competent officer authorized to receive and administer an oath.
Okay.
This is where the bureaucratic strictness of the law really shows its teeth. The state will not punish you for breaking an oath if the person who gave you the oath had no right to do so.
Give me a real-world example of how strict we are talking. Because surely any government official behind a desk counts. Yeah.
Not at all. Look at the case of People versus David. The facts are almost comical in their bureaucratic tragedy.
Okay, lay it out.
A defendant signed and swore to a demonstrably false document. They did it inside a government building. They raised their right hand in front of a government employee working behind a desk.
Sounds official enough.
You would think the prosecutor had a slam dunk.
Yeah.
But the defense lawyer dug into the administrative code. They discovered that the defendant swore the oath before a mere clerk in a municipal treasurer's office.
Uh-oh.
And under the law at that time, that specific level of clerk did not have the statutory legal authority to administer oaths.
So what happened?
Because the officer wasn't legally competent to give the oath was legally invisible. It never happened.
Wow.
And if the oath never happened, perjury cannot exist.
That is wild. The malicious intent is there. The material lie is there. The signature is on the paper.
Everything was there.
But because the guy sitting behind the desk didn't have the correct bureaucratic designation in his job description, the crime vanishes into thin air. It is a technical knockout.
It is a perfect technical knockout. Conversely, look at cases where the authority is clear.
Like what?
In People versus Batista, a false statement was made under oath during a preliminary investigation before a justice of the peace.
And they are authorized.
Unequivocally authorized. The perjury charge stuck. Or People versus Cruz, which involved a man signing a sworn application to take a civil service examination to become a patrolman.
Okay.
The law requires that application to be sworn before a specifically authorized official. He lied on it, the official was competent, perjury applies.
So the authorization of the officer is the literal gateway to the crime. If the gate is closed, there is no crime.
Exactly.
All right, I have a hypothetical scenario for you, and I call it the two statements conundrum.
Sounds intriguing.
This is based on a fascinating case from the sources, U.S. versus Capistrano.
Ah.
Let's say I am walking down the street, and I witness a horrible car crash at an intersection. The very next day, I go down to the police station, sit in front of an authorized officer, raise my right hand, and sign a sworn affidavit that says I was looking right at the traffic light. The light was definitely red.
Okay, sworn statement 1.
Fast forward 6 months, the insurance companies are fighting, and I'm called in for a formal deposition. I am put under oath by a competent officer.
Sworn statement 2.
And I swear, on the record, I remember it clearly now, the light was definitely green.
Oh boy.
I have now made 2 completely contradictory statements, both under oath, both on material matters, before competent officers. It is a logical, physical impossibility for both statements to be true. The light cannot be both red and green.
Very true.
So does the prosecutor just walk into court, wave those 2 pieces of paper at the judge, point to the logical impossibility and say, boom, perjury, lock him up?
It is entirely logical to assume that would work. The math proves one of them must be a lie. But the Philippine Supreme Court in U.S. versus Capistrano established a bedrock principle that protects citizens from their own confusion. 2 contradictory sworn statements are not, by themselves, sufficient to convict a person of perjury.
Why not? The proof of the lie is right there in black and white.
Because the burden of proof in a criminal trial is much heavier than just proving a lie exists. The prosecution must prove beyond a reasonable doubt which statement is false. And crucially, they must prove that the false statement was made willfully, deliberately, and maliciously.
I see.
If the prosecutor just shows the judge the red statement and the green statement, how does the judge know what was in your head?
That makes sense. Maybe when I talked to the police the day after the crash, I was in shock and genuinely remembered it wrong.
Exactly. Maybe 6 months later, you found a photo on your phone that proved it was green, so you corrected yourself.
So the prosecution cannot just use my own contradictory words to trap me.
No. They must do the legwork. They must bring in other outside evidence, a traffic camera, 3 other independent witnesses to prove that the light was, in objective reality, red.
And then?
Once they prove the light was red, they can then attack your green statement as the perjury.
They can't just use my bad memory against me. They actually have to find the truth first.
Exactly. And this leads directly to one of the most vital defenses in perjury cases, which was outlined beautifully in People versus Abaya.
What's the defense?
The defense of good faith and the absence of malice.
Good faith.
If you made a false statement under oath, but you genuinely, honestly believed it to be true at the time you said it, maybe you were misinformed by someone you trusted, maybe your angle of vision was obscured, maybe you misunderstood the complex legal phrasing of the question, you lack the willful, deliberate assertion of falsehood required for a conviction.
Because perjury is a crime of malice.
Precisely. If you acted in good faith, even if you were objectively wrong, you must be acquitted.
Okay, we've spent a lot of time talking about the nuances, the loopholes, the good faith defenses, the technical knockouts.
We have.
But I want to pivot to something that has no loopholes whatsoever.
Yeah.
And it is a massive modern update to the law.
You mean RA 11 Feed 94?
Yes. So what does this all mean when we look at the recent amendments under Republic Act 11 Feed 94? Because when I read that section, it felt like the law stopped being nuanced and just brought out a sledgehammer.
It is absolutely a sledgehammer, and it is aimed at a very specific, high-value target public officials.
Tell me more.
Republic Act 11 Fee 94 was passed in October 2021, and it significantly amended Articles 183 and 184 to include devastating new penalties, specifically for public officers or employees who commit perjury or offer false testimony.
Walk us through the new math for a corrupt official. How much worse is it for them compared to an ordinary citizen?
Under the amendment, if the person responsible for the perjury is a public officer or employee, the prison penalty is automatically imposed in its maximum period.
Wait, automatically?
Automatically. There is no leniency.
So the judge cannot use discretion to slide the sentence down to the minimum period due to mitigating circumstances?
Yep, nope. You get the absolute maximum prison time allowed for that specific tier.
That's harsh.
Furthermore, the offending official is hit with a massive fine of up to 1 million pesos.
Maximum prison time, 1 million peso fine.
Yeah.
But there is a third penalty in that amendment that is honestly the death penalty for a political or bureaucratic career.
Yes. Perpetual absolute disqualification.
Perpetual absolute disqualification.
Meaning
They are disqualified from holding any appointive or elective position in the government or in any agency, entity, or instrumentality thereof.
you are banned from public service forever.
Yes,
You can never run for office. You can never work at the DMV. You can never be a public school teacher.
exactly.
Why did the legislature feel the need to single out government employees for such extreme, unforgiving punishment?
It's a matter of trust.
Because if I, as a private citizen, lie on an affidavit, I get a few months, maybe a few years.
If a public official lies on an affidavit, they are financially ruined, given the max sentence, and permanently exiled from government. Why the disparity?
If we connect this to the bigger picture of how a society functions, it is all about the currency of public trust.
Right.
When a private citizen lies under oath, they are attacking a specific legal proceeding. It's bad, but the damage is contained.
Okay.
When a public official lies under oath, they are violating the fundamental social contract. A government employee derives their authority, their salary, and their power to affect citizens' lives entirely from the trust of the public.
They represent the state.
They are the sworn custodians of the system. If a custodian weaponizes their position to commit perjury, the betrayal is exponentially greater.
The damage is to the system itself.
Exactly. The state is making a philosophical declaration: public trust is our highest currency. Violating that trust requires the absolute harshest sanction, not just to punish the individual, but to aggressively deter corruption and maintain the basic legitimacy of the government itself in the eyes of the people.
It is the ultimate legal embodiment of, with great power comes great responsibility.
It really is.
If you choose to wear the badge or sit in the elected seat, the penalty for tarnishing the system is absolute. I actually love how clearly the law draws that line.
It leaves no room for ambiguity.
All right, let's move to our final section. We have spent this entire deep dive talking about the people telling the lies. The witnesses sweating on the stand, the individuals signing the affidavits, the corrupt officials.
The front-facing people.
But what about the people pulling the strings? What about the puppet masters? Let's transition to Article 184 and revisit Article 183 to look at the act of offering false evidence and subornation.
This is a vital component of the legal architecture.
Because often, the person lying has nothing to gain.
Right, exactly. Because very often, the person telling the lie on the witness stand has absolutely nothing to gain themselves. They aren't the defendant, they aren't the plaintiff.
So why are they there?
They have been placed there, or forced there, or paid to be there by someone else. Article 184 deals specifically with the act of knowingly offering a false witness or false testimony in evidence.
So, reading from the source, Article 184 states, any person who shall knowingly offer in evidence a false witness or testimony in any judicial or official proceeding shall be punished as guilty of false testimony.
Right.
And the penalty for offering the lie perfectly mirrors the penalties we already discussed in Articles 180 through 183.
Exactly.
So if you are the mastermind and you offer a false witness in a death penalty case, you get the reclusion temporal. If you offer a false affidavit in a civil case, you get hit with the $1 million peso fines.
Yes. The law treats the person who introduces the weaponized lie into the courtroom with the exact same severity as the person who actually speaks the lie.
Like a disease vector.
Exactly. If the lie is a disease, the person speaking it is the symptom, but the person offering it is the vector. The law punishes the vector.
But I need to push for a major clarification here, because the terminology in the case law gets incredibly tangled.
It can be confusing.
Let's say I am a lawyer, or just a really shady plaintiff in a lawsuit. I need a witness.
Okay.
I go find a guy on the street, hand him an envelope containing 50,000 pesos, and say, I will give you this cash right now if you get on the stand tomorrow and lie for me.
Classic bribery.
I am creating the lie. I am buying the lie. Am I being charged under Article 184 for offering false evidence?
No.
No.
No. And this is a critical, highly specific legal distinction found deep in the jurisprudence, specifically relying on cases like U.S. versus Belena and People versus Puto.
Okay, what's the distinction?
If you actively induce, procure, bribe, threaten, or convince someone to swear falsely, you are committing what is known in legal terms as subornation of perjury.
Subordination.
And surprisingly, subornation of perjury is not punished under Article 184. It is punished under Article 183, the perjury statute itself.
Wait, why? That seems incredibly confusing. Why am I charged under the same statute as the guy who actually told the lie?
Because of the foundational principles of criminal law regarding participation, if you intentionally induce someone to commit a crime, you become a principal by inducement.
Oh, so you share the crime.
Exactly. The crime the witness is committing is perjury under Article 183. Because you cause them to commit it, because your bribe or your threat is the reason the crime occurred, you are legally liable for their crime as if you committed it yourself. You share their exact charge.
Okay, so if bribing someone or creating the lie falls under Article 183, what on earth is Article 184 actually for?
That's the logical next question.
When does offering happen without inducing?
Article 184 is a very specific catch-all for when you present the false evidence to the court, but you did not create the lie or induce the witness to lie.
Give me a scenario.
Let's go back to you being a lawyer in a lawsuit. A witness comes to your office voluntarily. They hand you a document and say, I have this ledger that proves your client's case.
Okay.
You look at the ledger. Based on your own outside knowledge, you know for an absolute fact that this ledger is a complete forgery.
But I didn't forge it.
Exactly. You didn't forge it. You didn't ask them to forge it. You didn't pay them for it. They did it entirely on their own.
Right.
But you take that forged document, you walk into court, and you formally submit it to the judge as evidence. That is Article 184. You are knowingly offering false evidence that was created independently of your influence.
It is the I didn't bake the poison cake, I just served it to the judge defense.
And the law says serving it is still a massive crime.
Precisely. You don't have to be the baker to be guilty.
And the procedural rules are very strict about when this crime of offering actually occurs.
What is it?
According to Section 35 of Rule 132, the Rules of Evidence, there is a specific formal moment in a trial when testimony or documentary evidence is officially offered to the court.
The moment it goes on the record.
Furthermore, legal commentators note that Article 184 can be punished whether the offer is merely attempted or fully consummated.
Really?
Yes. The moment you stand up and try to formally inject that known falsehood into the court record, the trap snaps shut.
That is a massive warning to anyone involved in litigation. It is a warning to lawyers, to plaintiffs, to defendants. You cannot just blindly dump evidence onto the judge's desk if you know it is tainted.
You can't just feign ignorance.
You can't just shrug and say, well, the witness gave it to me, let the judge figure it out. Utilizing it makes you guilty. It forces everyone involved in a trial to act as a gatekeeper for the truth.
If we connect this to the bigger picture and really synthesize everything we have discussed today, the overarching architecture of the revised penal code regarding false testimony is incredibly elegant.
It really is. It's so detailed.
The severity of the penalty for a lie is perfectly calibrated to the damage that lie can cause. It is a brilliant spectrum of accountability.
From the top to the bottom.
It ranges from threatening a person's very life with a false criminal accusation, which triggers decades in prison,
Right.
to swaying a million-peso civil suit, which triggers massive financial ruin.
To breaking the public trust as a government official, which results in permanent exile from public service.
Exactly. The law recognizes that a lie isn't just words. A lie is a tool, it's a weapon. And the justice system punishes you based on the caliber of the weapon you chose to wield against it.
It is a brilliant, terrifying, meticulously designed system. Thank you for joining us on this deep dive. We have covered a massive amount of ground today. From the twisted mirror of proportionality, to the nuanced boundaries of expert opinions, to the bureaucratic technicalities of competent officers, and the sledgehammer penalties for corrupt officials.
It's been a very thorough journey.
But before we go, I want to leave you with a final thought to mull over. Something that builds on all these sources, but looks at the unintended consequences of such a rigid system.
Always a good thing to consider.
We have spent the last hour seeing how meticulously, how aggressively the Philippine law hunts down malice and the intent to deceive. The penalties are crushing, the technicalities are razor thin. But think about the chilling effect this might have on the actual discovery of the truth.
The fear it creates.
Imagine you are a bystander. You saw something that could genuinely help an innocent person who is on trial for their life.
Right.
But you also know that human memory is flawed.
Very flawed.
You know that if you get on the stand and your memory of the timeline is slightly off, or you get confused under the brutal pressure of cross-examination, and you accidentally trip over the legal difference between a material fact and a pertinent fact.
You could be facing prison time.
Right. If the penalties for getting a sworn statement wrong are this severe and the machinery of perjury is this complex, could these strict laws actually intimidate honest, but perhaps slightly confused witnesses from ever taking the stand to help a defendant in the first place.
It's a real possibility.
We started by saying the justice system is a machine that needs the truth to run. But when the price of an inaccurate memory is a prison cell, who is brave enough to feed the machine? Who is brave enough to testify?
A heavy question.
Think about that the next time you see someone raise their right hand. Until next time.
Welcome to the debate. You know, when we look at the anatomy of most crimes, we usually have a tangible physical metric for the damage left behind.
Right. There's a visible footprint.
Exactly. I mean, if a thief steals a watch, the justice system measures the value of the watch. If an arsonist burns down a warehouse, we calculate the property damage, the structural loss, the risk to human life. We measure the ashes.
But the courtroom is entirely different.
It is. What happens when you look at a courtroom? A witness takes the stand, raises their right hand, swears an oath, and tells a deliberate lie. No windows are broken, no alarms go off.
Yeah, the physical world is completely untouched.
Right. So the question we really have to ask is, how do you measure the footprint of a lie? Today on The Debate, we are looking at the hidden machinery of perjury laws. We're examining laws that try to put a mathematical price tag on deceit, specifically looking at how the Penal Code, Articles 180 through 184, treats false testimony.
It's sort of a profoundly murky landscape, honestly, because while lying under oath is universally punished across nearly all jurisdictions, but the underlying philosophy of why the system strikes back against the liar, that reveals a deep, unresolved tension in how we view justice itself.
I completely agree. And the central disagreement we are exploring today emerges directly from that tension within the statutory text. The core question is this: does this legal framework primarily seek to penalize the consequential harm caused by a lie?
Meaning, is the punishment directly proportional to the stakes of the case and the real-world damage?
Precisely. Now, I represent the position that this law is fundamentally structured around consequentialism. The Penal Code acts like a highly sophisticated ledger, scaling punishments directly to the specific gravity of the potential or actual harm inflicted on the victim.
And I represent the perspective that the law is fundamentally deontological. By that, I mean the law cares about the moral duty and the absolute rule being broken, not just the real-world consequences.
So focusing on the act itself.
Yes. This framework prioritizes the systemic integrity of the judicial process. It focuses on the malicious act of subverting truth. In my view, the measurable impact of the lie is entirely secondary to the fact that someone attempted to pollute the well of justice.
Well, let me lay out why I see this as a masterpiece of proportional justice. The law isn't dealing in abstract morality here. It is meticulously calibrating the punishment to match the precise danger the false testimony creates. Okay, walk me through that calibration. Let's look directly at Article 180, which deals with false testimony against a criminal defendant. The law doesn't just issue a blanket penalty for lying. It actually creates a strict, mathematically precise, 4-tier penalty system based entirely on the sentence the defendant is facing.
The sentence of the person they lied about.
Exactly. If the defendant you lied about is sentenced to death, you, the liar, face the severe penalty of reclusion temporelle, which translates to essentially 12 to 20 years in prison. The law demands a massive chunk of your life because you tried to take someone else's.
But that symmetry doesn't really tell the whole story of liability.
Wait, let me finish the thought on the scaling, because the mechanics of it are absolutely crucial to the intent of the framers. If the defendant is sentenced to something slightly lower, like reclusion perpetua or a life sentence, your penalty drops a tier to prisión mayor, or 6 to 12 years.
Right.
And if they get a lesser penalty, you get a lighter sentence, going all the way down to a minor prison term and a fine for acquittals. Lawmakers built this calculator for a very specific reason.
To deter high-stakes lies.
Yes, they are trying to deter witnesses, specifically when the stakes are life or death. The punishment is tethered to the exact consequence you tried to bring down on another human being.
I see that, but
Just one more point on this. We see this reinforced perfectly in Article 182 dealing with civil cases. The law introduces a strict financial threshold. If the amount in controversy exceeds 1 million pesos,
your penalty jumps significantly, including a fine up to 1.2 million pesos. If it doesn't exceed a million, the penalty shrinks.
You're pointing to the numbers on the page.
Because the law is literally holding a calculator. It is measuring the financial damage to dictate the penalty.
You are pointing to the physical footprint. Yeah, but I'd argue that is a dangerously simplistic way to look at justice in this context.
Simplistic? How so?
Because while it is true that the penalties scale based on the context, the liability itself, the very heart of the crime, hinges entirely on the corruption of the process and the deliberate malice of the offender. Let's look closely at the foundational doctrines under Article 180.
Okay, let's look at them.
Jurisprudence clearly states that criminal liability obtains even if the false testimony was not considered by the court.
Well, but the penalty still changes based on the court's ultimate sentence. If the court ignores the lie and acquits the defendant, the liar gets the lowest possible penalty under the statute.
The penalty scales, yes, I'll grant you that, but the crime exists even if the consequence is absolute zero.
Absolute zero consequence is a bit of a stretch.
Not at all. Think about the mechanics of what happens in the courtroom. A judge could hear the lie, realize immediately it is a clumsy fabrication, strike it entirely from the record, and acquit the defendant based on other solid evidence.
Right. The lie failed.
The lie failed completely. It caused no harm to the defendant. It didn't alter the verdict by a single degree. Yet the liar is fully guilty of false testimony under Article 180.
But they get a lighter sentence.
Sure, but if the law was purely consequentialist, a harmless lie would simply not be punished at all. There was no consequence. Furthermore, look at Article 181, which covers false testimony favorable to the defendant.
That's an interesting one, yeah.
According to the rulings in cases like People v. Reyes, the false testimony need not directly influence acquittal, and a benefit to the defendant is not required.
So the benefit doesn't have to materialize.
Exactly. The law is not measuring the consequence here. Think of it this way. The courtroom is a sterile laboratory designed to find the truth. A lie introduces a pathogen. The system prosecutes the introduction of the pathogen regardless of whether it actually infects the patient.
I mean, I see the elegance of the pathogen analogy. I really do. But if the law only cared about the absolute purity of the oath and keeping the laboratory perfectly sterile, then any lie spoken under oath would be punishable.
Well, they mostly are.
But that is empirically not the case. The law contains a vital safeguard, and that is the rule of materiality, specifically outlined under Article 183. If all lies matter to the system's purity, all lies would be punished.
This systemic view is actually profoundly deepened before we even get to materiality, though.
What do you mean?
Look at Article 184, which penalizes offering false testimony in evidence. The critical nuance here is that merely offering a false witness triggers the full penalties, applying equally to both attempted or consummated stages.
So just bringing them to the stand.
The mere act of introducing the falsehood is the crime. The court doesn't even need to evaluate the testimony yet. The law is fiercely guarding the process, stepping in the very moment the lie is spoken, regardless of where it lands.
I don't disagree that Article 184 steps in early, but it doesn't erase the materiality requirement, which dictates the criminality entirely.
Materiality is important, yes.
It's the whole ballgame. Jurisprudence like U.S. versus Strana and People versus Banzio dictates that there is absolutely no perjury where the lie does not relate to a material matter.
Right.
And a material matter is defined as the main fact subject of inquiry or a circumstance tending to prove that fact. Let's actually look at the mechanics of People versus Banzio.
The civil status case.
Yes. A witness made a false statement relative to their civil status in an immorality charge. It was a lie, it was spoken under oath, it was deliberate. The pathogen was introduced to your sterile laboratory, to use your terms.
But the court ruled it wasn't perjury.
Exactly. The court ruled it was not material to the specific charge of immorality, therefore no perjury.
Because it didn't affect the core issue the court was trying to resolve.
Right, which proves the court cares fundamentally about consequence. I compare it to firing a gun with blank bullets.
Blank bullets?
Yeah, if you fire a blank, you have the intent to shoot, you pulled the trigger, there was a loud noise, but there is no bullet that has the mechanical capacity to cause harm. If the lie doesn't have the capacity to alter the main fact of inquiry, the law simply doesn't punish it.
I see where you're going with this. The law requires competent proof on materiality because it is a pragmatist. Lawmakers recognized that the judicial system would grind to an absolute halt if it prosecuted every single boast, exaggeration, or irrelevant falsehood uttered on the stand.
So it's about efficiency for you.
It's about consequence. It doesn't care about a polluted well if the pollution is just a drop of food coloring that doesn't actually poison the water. It cares about consequential, measurable harm.
Well, your blank bullet analogy falls apart the moment we look at the liar's internal state.
How so?
If materiality, the capacity to cause harm, is the only thing that matters to the law, how do you explain spontaneous rectification? What happens when a material lie, a live bullet to use your analogy, is fired but the liar's mental state suddenly shifts?
You mean if the witness takes it back while still on the stand?
Yes. The precedent in People versus Amble establishes an incredible doctrine. It states that rectification made spontaneously, after realizing a mistake, negates false testimony.
Because they corrected the record.
Why, though? The ruling says it's because the malice or criminal intent to falsely testify is not sufficiently proven. Think about the mechanics of that scenario.
Okay.
A witness sits on the stand, tells a highly material lie that could absolutely swing a murder trial. The live bullet has been fired. The poisonous drop of food coloring is in the well. But 5 minutes later, the witness says, "Wait, no, I made that up. Here's the truth."
Right, they fix it.
But if the law was strictly consequentialist, the crime was already committed the moment the material lie was uttered. The danger was introduced. The consequence was risked.
But they mitigated the consequence before the trial ended.
The law forgives it entirely, because the doctrine explicitly states that good faith or absence of malice is a defense in perjury.
I understand the doctrine, but isn't that just a recognition of human fallibility rather than proof of a deontological framework? People get confused under the immense pressure of cross-examination. They misremember.
It proves the law is hunting the willful and deliberate assertion of falsehood. It is about the state of the soul of the witness, not just the state of the court record. We see the mechanics of this brilliantly illustrated in U.S. versus McGovern.
The handwriting expert case.
Yes. In that case, a witness falsely characterized himself as an expert in handwriting. The court ruled that falsity of a statement of opinion is not sufficient to convict under Article 181.
Well, I would argue that's simply because an opinion isn't a verifiable fact. You can't prove beyond a reasonable doubt that someone doesn't truly believe they are an expert, no matter how deluded they might be.
It is much deeper than just verifiable facts, though. You cannot maliciously subvert the truth with an arrogant opinion because the judicial machine relies on cross-examination to filter out bad opinions.
Right, the system works it out.
Exactly. The system is mechanically designed to test opinions. It is not designed to test fabricated facts. A fabricated fact bypasses the system's defenses.
That's a strong point.
When someone lies about an empirical fact, like "I saw him pull the trigger," they're deliberately trying to bypass the court's truth-finding mechanism. The law targets that deliberate bypass. It is policing the malicious intent to deceive the tribunal.
Okay, I grant that the willful and deliberate assertion of falsehood is undeniably an element of Article 183. But I view intent as a necessary filter for culpability, not the ultimate goal of the law.
A filter.
Yes, the legal framework requires malice because it cannot afford to punish accidental inaccuracies. Human memory is deeply flawed. If we punished every untrue statement, nobody would ever testify for fear of making an honest mistake and going to prison. So the law uses intent as a gatekeeper.
A gatekeeper to what exactly?
A gatekeeper to measuring the consequence. Once you prove the person lied on purpose, once you get through that gate, the law's eyes immediately lock back onto the consequence.
I disagree.
That is why jurisprudence distinguishes so carefully between pertinence and materiality as established in People versus Kapelak.
Remind me of the distinction there.
Mere proof that a lie is pertinent to the case is not sufficient. There must be proof of materiality. The lie must possess the mechanical leverage to actually break the scales of justice. Without that leverage, the malice doesn't matter.
Look, if we truly want to understand what a statute values, we have to look at what it considers the absolute ultimate breach of the law.
Okay.
What happens when someone doesn't just lie on the stand, but engineers the entire framework of the deception from the shadows?
You're bringing up subordination of perjury, and I actually believe this strengthens a consequentialist view.
How could it?
Well, under the doctrine established in U.S. versus Bellina, a person who procures another to swear falsely is held liable as a principal by inducement. The law doesn't just punish the person whose mouth spoke the words. It reaches behind the curtain to grab the puppet master.
Right, it goes after the organizer.
Exactly. Think about the mechanics of subordination. The mastermind is the one attempting to control the outcome of the proceeding. The person suborning perjury, maybe paying off a witness or threatening them, has the true vested interest in the consequential harm.
They have a motive, sure.
They want the acquittal of their guilty friend or the conviction of a rival. The law targets the architect of the harm, recognizing that the lie itself is merely a tool used to achieve a destructive end in the real world.
I don't buy that the outcome is the ultimate focus there. But even if I did, you have to look at the recent amendments to the Penal Code to see where the system's true anxieties lie.
You mean the 2021 amendments?
Yes, Republic Act number 11594, which amended Article 183. We see a dramatic shift in how the law views the ultimate breach here.
It increased the penalties?
Significantly. The amendment states that if the person responsible for the commission of perjury is a public officer or employee, the penalty is imposed in its maximum period plus a massive fine of up to 1 million pesos.
Right, it's very harsh.
But here is the most critical mechanism. They also suffer perpetual absolute disqualification from holding any appointive or elective position.
Well, that makes perfect sense. They are permanently removed from public service.
But ask yourself why mechanically? I argue this is the ultimate proof of the systemic, deontological view.
How so?
When a public officer lies under oath, the law doesn't stop to ask if the specific case they lied in was a 50 peso property dispute or a life or death murder trial. It abandons your calculator entirely.
It does apply universally to them, yes.
It hits them with the maximum period and perpetual absolute disqualification across the board. Because a public officer is a representative of the state, their lie is uniquely destructive. Not because the immediate case is inherently more valuable, but because their lie represents a terminal breach of the institutional trust the entire justice system relies upon.
They broke the social contract.
Exactly. The state essentially says, you didn't just lie to a judge, you degraded the very concept of government authority. The punishment is directed at the corruption of the system itself, entirely divorced from the stakes of the individual trial.
I see the weight of the disqualification penalty, and I agree it abandons the immediate scaling we see in Article 180. It absolutely removes the corrupted piece from the board entirely.
So you can see the point?
Not quite. I challenge the idea that this is divorced from consequence. I would argue that perpetual disqualification is simply a preventative measure against future consequential harm.
You are stretching the definition of consequentialism to cover anything that might possibly happen in the future at that point.
No, not at all. It is highly practical. A public official wielding state power has a massive capacity to inflict harm on citizens. If they prove they are willing to lie under oath, the potential future damage they could cause is astronomical.
That's entirely hypothetical damage, though.
You remove a lying official because of the catastrophic damage they could do tomorrow, not just to maintain a philosophical sense of systemic purity today.
That employs a law as just an exercise in risk management, rather than a profound moral judgment.
Law often is risk management.
But when you look at the totality of the jurisprudence, punishing lies that the judge immediately strikes from the record, punishing the mere attempted offer of false testimony under Article 184, forgiving a material lie if there is spontaneous rectification under the Amble Doctrine, the law acts much more like a guardian of a sacred process.
I hear that, but
It is protecting the truth-finding mechanism itself, rather than acting like a claims adjuster calculating damages.
and yet, we cannot ignore the strict mathematics built into the foundation of Article 180 and Article 182.
The scales!
Yes, a law that behaves purely like a guardian of a sacred process wouldn't offer a discount on perjury just because the defendant happened to be acquitted, or because the civil dispute was only worth a few thousand pesos.
That's fair.
The detailed calibration of penalties scaling directly with death penalties and million-peso disputes proves that this legal framework is a highly structured engine of consequentialist justice. It is meticulously designed to match the severity of the punishment to the potential damage of the lie.
It is a profound tension, and honestly, I don't think it's one that can be easily resolved today.
No, probably not. We both agree that Articles 180 through 184 create a highly sophisticated matrix. It attempts to balance the scale of the harm with the purity of the intent. The ongoing tension in the jurisprudence, how courts separate mere pertinence from true materiality, or how they weigh a public officer's breach of trust against a private citizen's financial lie. It shows that the law is constantly wrestling with its own identity. It truly is. The law is forced to be both a philosopher and an accountant. It has to measure the invisible intent of the mind, ensuring malice is present, while also calculating the very visible consequences that a lie unleashes in the real world.
Ultimately, the legal system relies on human beings to operate it, and human testimony is incredibly fragile. These statutes represent the system's best attempt to build a defense mechanism against our own capacity for deception.
For those listening, there is so much more to explore in the actual text of Articles 180 through 184. You really have to read the statutes and the jurisprudence to see how intricate this web truly is.
Highly recommend diving into those cases we mentioned.
We encourage you to look at the source material and decide for yourself. Are the scales of justice in these statutes weighing the damage caused to the victim, or are they weighing the damage caused to truth itself?
Every time a witness takes the stand, both are undeniably on the line.
Indeed. At the beginning of this discussion, we asked how you measure the footprint of a lie when there are no broken windows and no empty vaults. Perhaps the true footprint of a lie isn't left on the physical world at all. Perhaps the footprint is left directly on the scales of justice themselves, altering the balance for everyone who comes after. Thank you for joining us on The Debate.